portion. We got a part 3. It'll be all right, though. Check it out.
File my public assumed registered assumed name is on the record. I have the affidavit of publication. Even more proof that I am not the ens legis. I am not the legal fiction. Again, I'm the sole beneficiary of it. And under Rule 65.1, the fact that I've put myself in the rightful position to deal with this court, to deal in honor, Mr. Todd really has no evidence of me being the legal fiction. He cannot make me the legal fiction, Your Honor. I mean, much as he would like to, and much as I've been that in this court before, I filed the proper documents with the court. I'm standing in law right now and in honor. And again, he can sit there and say he ignored the conditional acceptance, but under law now he's agreed to it by a general acquiescence. I mean, and he's had plenty of time to respond to these claims, and he just refused. So clearly he doesn't have any actual proof of claim whatsoever. I mean, that's all hearsay. Everything he has over there is hearsay. He has no proof whatsoever. Again, and as far as jurisdiction go, I expect to see a affidavit of service on and for the record, Your Honor. I mean, it has to be on the record according to jurisdictional challenges, and he does not have that. He does not have it at all. I mean, I was never served by a process server. He's going off of what he hopes that the court would do for him out of recent times, I guess, but to end it, I'm not here as the legal fiction. I'm a sole beneficiary, paramount security interest holder for the collateral belonging to Willie Rochelle. 1501 Title 31 clearly lets him know who the obligations are on, and they are all on the government, Your Honor. I mean, we're still under bankruptcy, are we not, as a country? This is a UCC court. It states it clear, Title 31, 1501, who all the obligations belong to. So I'm just here to give him back his obligation.
All right, thank you, Mr. Rochelle.
Thank you, sir.
Mr. Rochelle is incorrect when he thinks this is a UCC court. This is not an absentee court. This is not a common law court. There is no contract necessary. This court, 2004, in a proceeding in which he was a participant, ordered him to pay child support. He had a continuing duty of support to that child. Our law in this state is that a parent has a continuing duty of support to a child, even in the absence of an order. And we actually have an order here. Also, in our law, Your Honor, the best interests of the child are paramount in all other considerations of secretary. He needs to support his child. I don't know who's sitting over here. He looks like Mr. Rochelle. I'm assuming it's Mr. Rochelle. Unless he's got some doppelganger. So, the child is not property. When the post-Civil War amendment outlawed slavery, so for him to argue that the child is property is nonsense. The child is only a ward to the extent that don't take care of the state's going to take care of somebody of this child. So, I mean, I don't know how to argue this. I don't know how to argue this. This is
This is solely a motion to dismiss and motion to strike.
Yes, sir. And I would ask the court to consider that under the rules of civil procedure, Rule 11, that pleadings, motions, or other papers are not to be interposed for any improper purpose, that is to harass, to cause unnecessary delay, or to needlessly increase the cost of litigation. Rule 11 also says that the claims, defenses, and other legal contentions are must be warranted by existing law, or they have to be a non-frivolous argument for either extending, modifying, or revising existing law, or for the establishment of new law. And the factual content has to have evidentiary proof. To the extent that he is trying to argue that something is unconstitutional, he has to serve the Attorney General of the state of Arkansas. I haven't seen any proof in the record that he serves the Attorney General. And we are asking the court to impose sanctions. dismiss his claim or actions to the extent that there are claims or actions, and I can't discern anything that deals with our statutes. Child support law in Arkansas is codified in 9-14-101 at C. It's also codified in Administrative Order Number 10. We are not a common law state. We have statutory laws, and that's what we follow. And that's what, under Washington, order to pay child support. The fact that he doesn't want to pay his child support is not an issue here. So the purpose of sanctions is to deter litigation abuse. And I postulate to the court that what he is doing is litigation abuse, that he is trying to just file as many nonsensical papers to the court as he possibly can in order to arrest and intimidate people. And under Rule 12, this pleading should be dismissed. The state claim upon which relief can be granted. So we're going to ask the court to strike the pleadings, to dismiss them to the extent that there actually are any pleadings, and to direct Mr. Rochelle to stop filing this nonsense. Thank you.
Can I speak, Your Honor?
How long you want to speak, Mr. Rochelle?
Just a few seconds. Thank you. Well, I'd like to speak toward what he said as far as the child not being a ward of the state, when the law clearly states in 1911, Act 215, that for the purpose of this act, all persons under 21 of age are considered wards of the state. It doesn't say if you don't take care of your child, you're considered ward of the state. It says what it says. It said minors are the ward of the nation, and even the control of them by parents. Even the control of them by parents is subject to the unlimited supervisory control of the state, and that's Clark versus Arkansas Democrat. I also like to say that the plaintiff's motion to strike and dismiss is only an attempt to fraudulently avoid the questions written in the alleged defendant's objection to motion for body attachment by use of deception and unlawful practice. Attaching fleshly body of a man by use of paper is in fact a direct violation of ancient maxim of law, desperado non debent jungi, which is dissimilar things ought not be joined. It's paper to paper and flesh to flesh, but not paper to flesh and flesh to paper. So wherefore I, a man known to use the name Willie Ray Rochelle, sole beneficiary and paramount security interest holder to the property and collateral belonging to Willie Rochelle, a United States citizen, doing business as Willie Ray Rochelle, the person of the corporate state of Arkansas, I object. And I'd like to ask this court to vacate and dismiss his motion to strike, dismiss his motion for body attachment, and dismiss pretty much all of his frivolous attempts to hide what he's really doing here in front of the court today. I mean, he's calling the disjointed prattle, and I mean, I got these are all case law, you know. I mean, I'm not making this stuff up, so. And I'm not sure what he means a statutory court. The Constitution trumps any statutes, and furthermore, like I said, my assumed name being filed with the county, I'm not an ins legis. He doesn't have authority. He doesn't have jurisdiction over my living, breathing body. He just doesn't. He has to have personal jurisdiction. He doesn't even have subject matter. He still hasn't shown subject matter. He's still just talking about it. So until he put proof on the record, Your Honor, which is due process requirement, which is the affidavit of service, which I don't have, which he never sent out, there is no way that he can acquire jurisdiction, Your Honor. And with that, I don't think the court can move forward to help Mr. Todd.
Thank you, Mr. Rochelle.
Thank you, sir.
I've read through the pleadings myself. Having read through the pleadings, I will grant the motion to strike and dismiss as they are in court's opinion. The only thing I have to say is they're frivolous. They're certainly for delay, perhaps increase the cost of litigation, and I cannot discern a claim on which relief can be granted. Also admonish you, Mr. Rochelle, in the future to not file any other baseless filings. I'm not going to add sanctions at this time, as the state is requesting, because of what's coming around the corner. When what's coming around the corner is done, if there are further pleadings, that the state is required to deal with, then the court will administer sanctions in the future. If you prepare to work,
Yes, Your Honor.
the court will be in recess.
All right.
So am I going into custody?
Yes, sir. But I'm gonna let you collect all your stuff and hand it off to you. The rest of it, what would you like to leave with her? If you don't wanna have to take it with you. Is that it? Anything else you wanna leave with her?
Sorry.
Anything else you need to give her before we take you into custody over in the cell? Okay.
Is that really necessary?
Well, he has an active warrant out for his arrest, so yes, we have to cuff him
Well, he's
before he can go.
willing to go.
I understand that, but everybody gets cuffed. That's just the general rule.
So you guys know that you can all be sued in your personal capacity.
That's not gonna help anything right now.
That's what's happening right now, though.
Move on. Okay.
That's fine.
And that was pretty much it. They railroaded the hell out of me. Pretty much is what they did. The judge, he violated so bad. So at this point, nothing else to do but file some claims, you know. Claim here, claim there against Michael Todd, against the judge, even against the sheriff, you know. So yeah, in the end, they took me to jail. I sat in there for 7 days, 6 days, 7 days or whatever. I filed an emergency Chapter 13 bankruptcy to disrupt the whole process, basically, and then take it out of that jurisdiction, put it in the federal jurisdiction, and I'm out now as of right now on automatic stay. So, but I don't plan on going to court for it. I'm gonna file more documents, and I'm gonna keep fighting. Bottom line, that's what I'm gonna do. I'm gonna keep fighting. But yeah, that was part 3. They tried to get me. I got another video my brother, he recorded when I ended up going to court for the hearing. After I filed a bankruptcy, the judge held a hearing days later. So that's how I'm out free now. And he ended up suspending the other 25 days in jail. He claimed because he don't believe it's going to do any good, me sitting in jail, blah, blah. He don't think it's going to help the situation, period, like whatever. But fact is, he couldn't move forward anyway, as long as the automatic stay was in place. So it was some bullshit also, but I'll post it later. But anyway, I could have did a few things better, you know, not gonna lie. I mean, I'm gonna be too hard on myself. And that court shit, man, it's a serious situation, so, cause they got your life in their hands, so. But, it's not over. The fight ain't over by far. I got some good people in my corner, you know, so I'll be all right. I just want y'all to see that. Because, you know, people are like, oh, he went to jail, they talk all that shit, he went to jail. But I got out of jail, you know what I mean? So, the thing is, it's a fight. If you don't fight, you won't win, period. You can sit back and not fight and not win. Or you can fight and win, but you're going to take your losses anyway. So, I'm not mad about it. I mean, I gained a lot of perspective out of the entire 6-day little stay in jail. So, and you know, I got some benefits out of it. It was some bullshit, nevertheless. And they will answer for the shit. Trust me. But, you know, you take the good with the bad, you know. They always try to give you the bad. Hell, he was so shocked to see me back in court for that hearing. He was like, I just sent this motherfucker to jail. And I'm right back in his face days later, and he got to let me go. And so, it was still a win. I had to take a different route. But at this point, all I've done, everything I've served them with, the steps I've taken, we to the point now where they just totally disrespectful. And now it's time to file some claims. Simple as that. I mean, ain't nothing else to do. So anyway, just wanted to share that with everybody. So you get a clear perspective how to deal with these people. You don't have to go on court and just be their bitch. You know what I mean? You got a voice, use it. You know what I mean? Brush up on the shit. I know I got some more levels to hit for damn sure. It's a lot more knowledge out there, and experience is a must. You got to go in there. You at least got to try. Keep trying. You didn't do good that last time. Go in there again. Try it again. Because they're going to keep fucking with you anyway, so you're going to always have another opportunity. So, until you dead them, of course. And that's the goal. Just to dead all this shit to where you ain't got to go in there and you got to fuck with them. You got to speak with them. You got to deal with them at all. But this particular fight, I've been doing it for 5 years. So, it's a little deeper hole to climb out of. So, anyway, take what you want out of it. Critique it. Piss on it. Shit on it. I don't really care. Tell me I did this wrong. Tell me I did this right. Blah. I don't really give a shit. I just want to share it. Anyway, y'all be good. Later. Southern.